Okay.
So,
Good evening, everyone. My name is Steve Hernandez, and I'm the Executive Director of the Legislature's Nonpartisan Commission on Women, Children, Seniors, Equity, and Opportunity. And we are here today to discuss our paid family and medical leave program with our co hosts and co sponsor, the CEO of the program, Andrea Barton Reeves, Esquire. I'm so excited to welcome you, I have to say, because this was a Herculean effort to get paid family and medical leave adopted in a way for the state of Connecticut that made sense for the people of the state, but was also sustainable and thoughtful. And so much of that really relies on your building of this program, but also in the implementation. So we're so excited to be here with you today. I'm going to pass the baton on to you, and I'm excited to hear where we are and where we're going with the program. Welcome.
thank you so much. I appreciate the opportunity to be here today. I too was looking forward to speaking to the committee. You do extraordinary work in normal times, and you continue to be really outstanding advocates. I know it's been challenging since the committee has been consolidated to have all of the individual voices of your constituencies heard, but you've really done a fantastic job in continuing to do the work that the committees were doing individually and continuing that work collectively. So let me start by sharing my screen, and then what I will walk through the basics of paid leave and then entertain any questions you might have afterward. All right, so Amber, if you could let me know if my screen is visible.
Yes.
All right, wonderful. Then I'm going to just do a few things here. So I can see like this so far away. All right. Need to hide the panel so it will, there we go. So I can put it in slideshow mode. And here we go. All right. Again, thank you for the opportunity to be here today. My name is Andrea Barton, and I am the CEO of Connecticut's Paid Leave Authority. With me today, I have my Chief of Staff, Andrea Comer, and our agency's Executive Assistant, Amber Forrest. I began this role in March of last year, the second, which, if those of you are counting, was only a few days before our state went into complete lockdown because of the COVID-19 crisis. And we remain in some version of that now to this day, almost a year later. Prior to coming to the Pay Leave Authority, was the CEO at HARC, which supports people with intellectual disabilities and their families. I also served as the agency's Vice President of Administration and in-house counsel before I became its CEO. I have been active in the community and some of the organizations that you can see listed there. I am from New Jersey originally. I've lived in Connecticut for 24 years, and I've raised my son here, who is 20, and I have a degree from Rutgers in English, and I have a law degree from New York Law School. So today we'll have an overview of the paid leave program itself, some of the key dates that you and your constituents of your respective committees, excuse me, constituencies should be aware of, an overview of the law itself, how the benefits process will work, with some questions that employers might have and putting that into practice, and then a review of some additional resources, and then some questions and answers. Starting out by just talking about the Paid Leave Authority itself, it was signed into law in July of 2019, and the authority was established because we really have a growing need in this state, and we really feel that now to provide financial relief for families, especially when they're caring for loved ones or themselves without having to make these draconian decisions about either going to work sick or losing income and remaining home as they try to recover. Our mission is twofold, and that is to provide pathways to accessible paid leave benefits, and also to empower employers and administrators and healthcare providers by offering them tools so that they can understand their role and give them support as they're navigating the program. We have 5 primary responsibilities at the Paid Leave Authority. They are outreach and engagement. So again, we're delighted to be here today to develop the policies and procedures needed to run the program. We established the trust fund contribution rate, which is the 1/2 of 1% that is being withheld from wages starting January 1 of this year. We approve and audit private plans, which is an employer's opportunity to offer a plan that is the same as the state's plan with some exceptions. and we administer claims for paid leave benefits, and that will begin in January of 2022. So who is covered by this law? Covered employers include those that have one or more people working in Connecticut, and that includes not-for-profit entities and private sectors employers that have a unionized workforce. Those in our workforce who are sole proprietors or self-employed individuals may opt into the program at any time, but if they do so, they have to remain in for a minimum of 3 years. Those employer entities that are not covered include the federal government and some employees of the state of Connecticut, except those that are covered public employees, and I'll have a bit more of an explanation on the next slide. Municipalities and local or regional boards of education are also not covered employers unless they too have covered public employees. The category of employer that is completely accepted are non-public elementary or secondary schools. Covered public employees include non-unionized employees of the state of Connecticut. And it also includes those unionized employees who collectively bargain for inclusion in the program. For those who work for municipalities or local or regional boards of education, if the unionized employees of those bargaining units vote to be included in the paid leave program, then that inclusion applies to all of the employees at the municipality or the local or regional board of ed, whether they are in the union or not. As you can see at the bottom of the slide, there is an expansive definition of municipality. So it may apply to a number of employees to whom we may not traditionally think would be municipality employees. As I mentioned earlier, the withholding of the 0.5% of wages began on January 1. And here's the cycle of how those contributions are managed. They are collected from the employee, and the employer is responsible for remitting those and accompanying wage information to the paid leave authority. We then accept that information and we validate it using data that we receive from the Department of Revenue Services and the Department of Labor. Those contributions are deposited into our paid leave trust fund, which is managed by the Office of the Treasurer. And that trust fund is how benefits are paid starting in January of 2022. Some key dates that you should know about. We launched our website on September 4th, 2020 at ctpaidleave.org. You will find an enormous amount of information about paid leave on that site. The site is available in English and Spanish. It is also completely accessible. So we've had it screened. So if you have low vision or if you are blind, you can also continue to use the site. Registration of all employers are due now. That we know that employers are aware of their obligation to withhold the 0.5%, which, as I mentioned earlier, started in January 2021, and benefits will be accessible in January of 2022. So what are some of the reasons that leave can be taken under the law when it changes in 2022? Leave can be taken to create or expand your family through birth, adoption, or foster care. You may also take leave to care for a family member with a serious health condition or for your own serious health condition, which can include serving as an organ or bone marrow donor or for pregnancy. There's special leave available for those who are serving our country, where a family member can take time to take care of someone who has been injured during active duty. There's also qualifying exigency leave so that a family member can spend time with one that is being called overseas to active duty. And what is unique to our law in Connecticut is that up to 12 days of the 12 weeks of leave available may be taken by those who are impacted by family violence. Here's a chart that basically gives you an overview of the leave laws. As we sit here today in 2021, we have our current Family and Medical Leave Act, which applies to employers with 75 employees or more. And those employees had to have worked at least 12 months and 1,000 hours for that employer in order to access family and medical leave benefits. Their ability to get their own job back when they return from leave is available to them after having worked that 12 months, and they can take up to 16 weeks in a 24-month period. The employer can now require an employee to use all of their accrued time in order to get paid for the time off from family and medical leave, and no time is permitted for family violence leave. In 2022, this changes. An employer of one or more employees will be subject to the Family Medical Leave Act, There will no longer be an hours worked requirement, and job protection will attach after 3 months. There'll be now 12 weeks of leave in a 12-month period, although 26 weeks of leave will always be available for military caregivers, with only 12 of those paid, and an additional 2 weeks is available for those who are incapacitated during pregnancy. So while an employer under our current law, could require an employee to use all of their time off, they now must allow an employee to keep up to 2 weeks of their accrued leave, and up to 12 days of the leave may be used for family violence and, for dealing with the impact of family violence. The federal FMLA, for those employers that are 50 employees or larger, continues to remain as it is. You still have an hours worked requirement. Job protection attaches at 12 months. There's the same type of leave, 12 weeks. An employer can require the employee to use their time off, but that 2-week requirement is incorrect on this slide, so I'll have to fix that. And there is no time permitted for family violence leave under the federal FMLA. So I mentioned earlier about job protection. There are some circumstances when someone takes leave, and when they return, they are entitled to come back to their specific job, or if their job no longer exists, to an equivalent job. That job protection attaches under the federal law after 1 year. It may also attach under laws such as workers' compensation, the Americans with Disabilities Act, the Pregnancy Disabilities Act, and the Connecticut Fair Employment Practice Act. Income replacement will be available in 2022 under our paid leave law, and workers' compensation remains a viable option for those who have injuries on the job, illnesses that are covered under the law. So what happens with respect to eligibility for family and medical leave? Again, the federal leave remains in place, and for the state leave, for job protected leave, the employee has to have worked for the employer for at least 3 months. And the reason for the leave has to be covered under the statute. The employee has to have some leave available, meaning they've not exhausted all of their leave, and their employment status must be one of two. They have to be currently employed, or they were employed and working during the last 12 weeks, or they're a sole proprietor or self-employed individual who's opted into the plan. In addition to that, and we will add this to the slide, the person has to have earned $2,325 in the highest earning quarter of the last 4 of the 5 quarters in order to be able to access leave. That leave might not be job protected, but earning is a requirement in order to qualify for paid leave benefits. So some of the primary differences, and one of the primary differences between the federal law, which is why we talk about it so frequently, and the Connecticut law, is the definition of family member. So under federal FMLA, that definition is rather narrow. You can take leave to care for a parent, a spouse, a child who's under 18, or if they're over 18, they have to have a disability. Under the Connecticut law, when it changes in 2022, that definition will be quite expansive. It will include parents, spouses, sons or daughters of any age, or children of any age, we should say, siblings, grandparents, grandchildren, or individuals with whom the employee, either by blood or affinity, has a close association that is equivalent to one of these family relationships. So what does that mean? Related by affinity means any person with whom the employee has a significant personal bond that is like a family relationship, regardless of their biological or legal relationship. And this, of course, is completely situational. So as an example, let's take the third or fourth bullet down. So you may have an aunt or uncle who relies on the employee for unpaid care, and they've maintained the strong, enduring relationship as they might if they have a parent or grandparent or sibling. I know this personally. When my aunt was alive, I was primarily the person who was responsible for caring for her after a number of accidents and health conditions that she had. I would not have been able to do that under family medical leave as is covered, but when the definition changes in 2022, that would be available. Another condition or circumstance that's more familiar with people, or a couple that lives together, unmarried, a significant long relationship, and they have a familial spouse-like relationship, regardless of the fact that they are not married to one another. They may also be considered a spouse for the purposes of the statute and related by affinity as such. What is the role of the employer when an employee comes to them and requests leave? They really need to ask two questions: whether that employee is eligible for job protected leave under the FMLA or some other statute that we outline, and whether that employee is eligible for income replacement. Because there might be times when the employee may have job protected leave, let's say with the Americans with Disabilities Act, but they may not be eligible for income replacement because their reasons for leave might not be covered under a statute for which income replacement is available. Just a little bit of background and facts that you should consider. There is, of course, job protection that's available under these four acts that we mentioned earlier. And then the question of whether or not a person can receive benefits from their employer and the paid leave authority at the same time often comes up. And the answer is yes, but those combined benefits can never be more than 100% of the employee's regular wages. Some employers have plans where their short and long-term disability insurance requires that the state-provided paid leave be utilized first and before the employee can access any private benefits, and that certainly can be the case in certain workplaces. But you should also know that when it comes to workers' compensation, an individual who's receiving workers' compensation benefits is ineligible for paid leave benefits from the paid leave authority at the same time. There might be times when a person may be eligible for paid leave. They may not have worked for an employer for 3 months, and therefore they have paid leave with no job protection. And so this is a circumstance that employers may have to consider. Finally, employers may require their employees to use their sick, vacation, or their accrual, or other types of PTO accruals. But starting in 2022, employees are entitled to keep up to 2 weeks of their leave, and they cannot be forced to exhaust it in order to cover any or part of their time away under family and medical leave. The question we get most often is, how do people access their paid leave benefits from the authority? The first thing that they will do if they're not a sole proprietor or self-employed is they will submit their application for leave for their employer, who will then approve that leave. And then there will be a dialogue had as to whether or not that person has any time off, short-term, long-term disability, or any other income replacement options so that they can be paid during the time that they're away. If in fact they do not, they will then come to the paid leave authority and apply for those benefits. We will validate their eligibility. We will do some calculation of their benefits. We will validate their actual covered absences and whether or not they have any other kind of time off that will offset the benefits they've received from the authority, and then we will issue their benefits payments. And here's just a brief overview of what those calculations are. If a person is making $480, meaning that their base weekly earnings are less or equal to the minimum wage multiplied by 40, which here is $480. Their maximum weekly benefit will be 95% of their base weekly earnings, and the maximum benefit they could receive is $456. If they are earning more than 40 times the minimum wage, the Connecticut minimum wage is just $12 multiplied by 40, they will receive that plus 60% of the amount of their earnings that exceed the base multiplied by 40. And the maximum benefit they can get is $720. So here are a couple of examples of that. Mike makes $375 a week, so his wages are less than or equal to the minimum wage multiplied by 40. The maximum weekly benefit that he could receive is $456, but his weekly benefit, 95% of his $375, is $356.25. Deborah makes considerably more. She makes $700 a week. So she starts out by getting her $480. Then she, in applying the formula, gets an additional $132, which means that she gets $612 in weekly wage replacement under the Paid Leave Act. For those employers where spouses work for the same employer, under the federal law, they are required to share their leave if they're caring for a child new to their family or caring for a parent with a serious health condition. And the same is true under the state law, where they must share their leave if they're caring for a child new to their family or caring for a family member with a serious health condition. But starting in 2022, spouses will not be required to share their 12-week paid leave for any reason. You heard me speak earlier about private plans. This is an option that's available under the paid leave statute that allows employers to create their own plan in lieu of having their employees participate in the public plan, but they must meet certain criteria in order to do so. The first is that their plan must offer same or better benefits as the public plan. And under no circumstances can it cost the employees more than the public plan. And that contribution has to be limited to 0.5%. They have to be able to administer the claims and benefits and demonstrate the ability to do so. They also have to hold a vote of the employees to seek their approval of the private plan option. And a majority of all of the employees who work in the state, regardless of where the employer is headquartered, have to vote in favor of the plan in order for it to be viable. And finally, the paid leave authority has to approve the plan. If an employer has a paid leave authority approved private plan, then they are responsible for determining whether an employee is eligible for benefits, and they are responsible for making sure that that employee has income replacement while they are away. A little bit about the private plan process. Employers are registering now. Soon they'll be able to go back and submit a complete application that will be reviewed for approval. And then they'll be able to go in and give us their final policy so that we know that what they offer their employees for the vote is exactly what their employees will be getting. Here are, I think we're up to 16 insurers that have expressed an interest and are approved to offer private plan insurance in the state of Connecticut. So there is a lot of opportunity and a lot of choice for private employers who wish to offer a private plan. I've covered a lot today, so let me just tell you where some other resources might be available. They are at our site, ctpaidleave.org. If you go to the employee page of that site, you will find a number of these documents, and they are also very much available on the employer page. There is an employee rights poster that summarizes all that I spoke of today regarding benefits, calculations, all of those things. Using this QR code takes employees to a site, a page on the site, where they can actually calculate an estimate of their contribution to the paid leave program. So if any of the people that you support or come in contact with say, I don't even know what the 0.5% is, there's a calculator on the site that will help them to figure that out. There is what we call an employee rack card, which is actually just a smaller version of the poster that's easier to carry around, quite frankly, in more condensed manner. The employee paycheck mailer is by far the most downloaded document on our site that explains what the 0.5% is. There's also in a different form an employee fact sheet, and for employers who may have some questions, there is a comprehensive 24-page employer toolkit that can be accessed that explains all that I just spoke of today. Again, here's this site, ctpaidleave.org. And for employers who may be asking you, well, what do I do next? You may have been hearing ads on the radio. You may have seen us on television. We're asking employers to register now. And if they use a payroll provider, to make sure that provider is ready to withhold the 0.5% and remit those dollars to the authority's trust fund no later than the end of April. To please educate their employees about the withholding and about the benefits that will be available in 2022, and to visit the site regularly for updates. And finally, we're here to help. If you go to the website and go to the Contact Us feature, submit questions or concerns there, and someone will respond to you as quickly as possible. There are also over 160 frequently asked questions and videos, and the site is fully available in English and Spanish. So thank you. Appreciate your time. I'm going to stop sharing my screen and can ask some questions.
All right, Andrea, thank you so much. I'll be doing the Q&A with you tonight.
All right.
So we're going to start with the first question. I am an LLC with only myself working. Do I need to enroll this program? Am I considered a sole proprietor?
You, in fact, are considered a sole proprietor if you're the only person. I know that if you're the only person working for yourself. So here's the thing that's been a bit confusing. We know that people are working only for themselves and have no employees, but they still may be an LLC for tax purposes or insurance purposes or other reasons. But you still have the option of enrolling, but remembering if you do so, you have to stay in for 3 years. So yes.
Thank you. Is it 50 plus employees overall or just in the state of Connecticut? My company has locations in multiple states and does not have 50 employees in Connecticut alone.
All right. So the standard is 1 employee or more who work in the state of Connecticut. Where we mentioned the 50, that means that for your if you have 50 employees or more, you're still obligated under the federal law to offer family and medical leave. And you still have to offer leave under the Connecticut law, which will change in 2022. So before, as we stand here today, it was easier to offer both federal and state at the same time. We often say we run them concurrently or parallel because the reasons for leave are very much the same, the eligibility requirements were the same, and the time off were almost identical. What's going to be more challenging for employers now is that the federal FMLA is going to look very different than the state FMLA in 2022. So it'll be harder to run those things concurrently. Most employers don't think that they'll be able to. But remember that the new threshold for the new state law in 2022 is 1 employee or more.
Thank you.
Mm-hmm.
If employers are subject to approving the leave, then how do we decide or approve it if it is being taken for the right covered family member? The new definition is quite broad. What types of proof can we request from these employees?
Yeah, that's an excellent question. So we're working with the Department of Labor right now because they are the ones that actually set the standard and they hear grievances if there are any issues or concerns about the definition of family. They are determining whether there will be an attestation, which is essentially a writing that says this person is related to me in this way, and here's how I can demonstrate that, or if it will be an affidavit or some other form of proof that they have. States vary. We're not the only state that has this definition. There are about 3 or 4 others that do. There are only 9 states that have family medical leave right now. I think there are 3 other states that use this broad definition, and some of them require an affidavit and photographic documentation, which sometimes can be created. We know this with Photoshop, so that's not always as reliable. And they may also require some other kinds of writing. So that's not quite yet defined yet, but a person will not just be able to walk into your office and say, hey, you know, the person who lives next door is like a sister to me and I'm going to take 12 weeks off to take care of her. That's not how it will work.
Great. Where do we make deposit payments into the program? I do my own payroll.
Okay, great. So soon, maybe meaning probably before the end of February, we will be releasing information on exactly how you will make payments, but they will be made through the ctpayleave.org portal. So that is not only the website, it's the way that you register, it's where you get information from, it's where you apply for your private plan, and it is also the place where you will make payments. So we will be releasing specific information and training on how you will do that. So I don't want employers to confuse this with My Connect, which is with the Department of Revenue Services. And we know that there's been a bit of confusion about that, but that's not where you make your payments. You make it all through the ctpayleave.org site. Once you've registered. Yep. Once you register, you do everything right there.
Are employers expected to provide the calculation of potential pay to the employee, or does this rest with the state administration?
Yes, no, you are not expected to do any calculations. It's one of the reasons why we have the benefits calculator, the contribution calculator on the site now. And then as we get closer to providing benefits, then you will also see a benefits calculator on the site as well. You are not expected to do that level of calculation or any calculation at all. We will make sure that that's covered.
Great. And I'll drop a link to the contribution estimator into the chat if anybody's interested in taking a look at that.
Yep.
We use QuickBooks and have this set up in payroll. Will we get a statement from Connecticut when we need to send a payment?
So yes, I think we are planning on issuing statements, but I don't know that for sure. So let me get back. We're just at the end because payments aren't due until April. We're in the testing phase of the payment processing now. So there'll be an announcement as to whether or not there will be statements. I think if employers want a specific, the idea is that we won't be sending them proactively. If an employer wants a statement, we'll be able to provide those. But right now it's not designed to send out statements because a lot of employers have told us we don't want anything else from any other state agency. If we need it, we'll ask you for it. So we're taking their feedback and advice.
If leave is in December, then the employer still has to preserve, does the employer still have to preserve 2 weeks of vacation time?
Yes, they do. Yeah, so the time, I think, if I'm understanding the intimation of the question correctly, or the inference being made from the question, that I'm drawing from the question, I should say, is that if you have to use your leave up before the end of the year, or there's some other condition around leave, do you still have to give the person the 2 weeks? And the fact of the matter is that you do. If they're going to take the leave, you do have to withhold that 2 weeks and allow them to keep it.
Okay. Some employees are asking what happens to their contributions if they move out of Connecticut and never take advantage of their contributions to the trust.
Yeah.
What is the message to those employees?
The message to those employees is that those contributions are not refunded. It is a trust fund. So if you think about it as insurance, that's why we're the paid leave insurance authority. Everyone pays into it. It is available for those that access it. If you move out of state and you don't use it, there is unfortunately not a refund mechanism for that purpose.
Okay. And as a sole proprietor, do sole proprietors need to let the state know if they'll be opting out of the plan?
No, you don't have to let the state know that you're opting out. You only have to let us know if you're opting in. So if you want to think about it for a while, you never want to participate, or you just want to see what's going to happen, which some employees, some sole proprietors have told us that maybe they'll explore some of their other disability and payment options. That's fine. That's fine. Yeah, you don't have to let us know either way. You can just continue as you are until you make a decision one way or the other.
Okay. The next one is, are all companies obligated to register?
All companies that have one or more employees are obligated to register, yes.
And if you have under 50 employees, are we only obligated under the state FMLA?
No, so if you have under 50 employees, well, that's a great question. Yes, so if you have fewer than 50 employees, then you would not then be subject to federal FMLA because you have fewer than 50. But if you have one or more, you're still covered by Connecticut's FMLA starting next year.
Okay. Where do the employees get the application to submit for leave?
So we will be creating an application process for you. So if you already have 75 or 50 or 75 more employees, and you're probably using a form that's already been created by the state or the federal government. Sometimes people just use the one form for both. We'll be adapting a form of that form for you so that it's something you're already familiar with. If you're not, because you have fewer employees and you have no access to, and you've not been exposed to paid family and medical leave or family and medical leave before, then we'll create a form that's easier for everyone to use. So you won't be providing it, and we'll expect employees to go to our website and download that form. Some employers download it and keep it in bulk in HR. If we ever get back to offices again, there'll be ways that you can access it, but it'll be online as well as something you can download and keep in your offices if you choose to do so.
Okay, great. Can you confirm again the process for applying for benefits? This
Yes.
is actually a multi-part question.
Okay.
Is the employee spouse to apply for their employer's leave, wait for approval or denial, and then apply for Connecticut benefits? Or can they apply simultaneously for both?
The employee and the spouse, or the employee's spouse?
Is the employee supposed to apply? I think I said spouse, but it's
You did.
supposed. Sorry about that. Supposed to apply for their employee. Supposed to apply for their employer's leave and then wait for approval or denial to apply for Connecticut benefits, or can they apply simultaneously for both benefits?
No, we are really encouraging employees to go to their employer first and apply for leave there, because what we don't want is employees to just show up at the paid leave authority and say, hey, I'm taking 8 weeks off because I'm getting something replaced or some type of surgery. That's not the intent of paid leave. If you think about it in two parts. So there's the family and medical leave part, which larger employers, meaning those that have 50 or 75 employees or more, have always managed. So employees have always gone to those employers and said, I need to take leave. I have a qualifying reason. I've worked for 12 months. I have my 1,250 hours and I qualify and I'm going to take my leave. The employer has always been responsible for making the determination as to whether or not that person qualifies for leave if the employee brings them the appropriate documentation. So that's the role that employers will continue to play for employers who are familiar with this, and it's a new role for employers who are not familiar. So then once you make that decision, Then you say to the person, okay, well, that's fine. You know, you have worked whatever period of time you've worked here, and you have the time that you have, and you have a reason for leaving. You've presented me with the appropriate documentation, but you know, you don't have any time, so you can't get paid for it. Say they haven't accrued enough time. So you can go to the paid leave authority and get paid for the time that you will be away. Because right now, if someone comes to an employer and applies for family medical leave and they otherwise qualify for it, they're only paid if they have enough accrued time to cover the time that they're away. This is really where the difference is now. Now there's a place for them to go to get income replacement for the time that they're away.
Okay, great. We offer paid parental and adoption leave. Can this run concurrently with Connecticut paid leave?
It can if you choose to. So that's where benefits coordination really makes a difference. So let's say that your employee wants to take, I don't know if you offer it incrementally in hours, or if they take it by days. That's why we say to employers, that you need to ask those two questions, right? Whether or not someone has job protected leave and whether or not they have income replacement. Because when you have that dialogue, that's when you can say to them, well, we offer this benefit, and perhaps you can work out a plan together where the person can cover the time that they have off for parental leave and have adequate income replacement.
All right, thank you.
Sure.
Can you please clarify what constitutes an incapacitation during pregnancy? Would this apply to every pregnancy, or is it just if there are complications that require greater than 12 weeks to recover?
That is a terrific question, and it depends on the person. So incapacitation is not defined under the statute, so that's not particularly helpful. So we've looked to similar laws to help define incapacitation. For pregnancy, it really is, the need for bed rest, as an example, would be an incapacitation, or there's some other complication that arises as a result of the pregnancy. So you have got extremely high blood pressure or preeclampsia or something else, you've got a separated placenta, some of the other things that can happen as a result of pregnancy, then your healthcare provider says you need additional time for rest or additional time for recovery. So, but the statute also reads it's for incapacitation during pregnancy. So what the Department of Labor has said to us is that if a person, for example, if a woman has a very complicated birth or a complicated cesarean section, that additional 2 weeks is not something that they can take at the end after they've given birth. But if they need it during the time that they're pregnant, they can take that time then.
Okay, great. Should the contributions be deducted from employees pay on a pre-tax or post-tax basis?
Yes. So it's FICA. So it's the number that you come up with in order to calculate FICA. So once you've got your FICA number, which is your gross wages and the percentage of your Medicaid and your Social Security, that the number on which you calculate what you need to determine what their FICA obligation is, that's the number that you use for the 1/2 of 1%.
Please confirm the maximum payable to highly Please confirm if the maximum payout to a highly compensated employee is $720 a week.
Right. So it can't be any higher than 60 times the minimum wage. So right now our minimum wage is 12, it'll go up to 14, it'll eventually go up to 15. So that will be the maximum benefit no matter what anybody earns. That's the most anyone can possibly get. For high wage earners, the contribution rate is capped at the Social Security rate, which right now is about $143,000. So if you make anything above that, your 1/2 of 1% is capped at that Social Security contribution rate. So I know that question wasn't asked, but they always go together. So I figured I'd just answer it.
That's helpful.
Okay.
What resources are being provided to towns, legislators, women's health centers, and businesses that will expand knowledge of the program?
Yes, so we have given close to 80 webinars last year on paid family medical leave, and we'll probably do the same coming up this year. We've been to virtually every chamber of commerce, lots of municipalities. We've done a presentation. I think we're about to do a presentation for the Connecticut Council on Municipalities. We've done it for the Committee on Women and Girls, and we'll just continue to do it. If you have an organization, a trade association, or any large or small group that you think that we should be talking to that we haven't already, please tell us that. Like, drop it in the chat now. Go into the contact us site, send us an email, let us know, because we want to get to as many businesses and individuals as we possibly can.
Absolutely.
We're willing to do another 80 webinars next year. It's not a problem.
Not at all.
Yeah,
We're pros
we'll
at it at this point.
That's right.
Here's a situational question. I have
Okay.
had employees who are planning for retirement this year or early next year. And if they do they still have to contribute since they will not be using the benefits?
Yes, they do. And I know this is a point of, well, on the one hand, frustration, bewilderment on one end of the spectrum, and just outright anger and just irate behavior on the other. And I've experienced both with people. But that is the way the statute is written. And one of the things we tell people is please, please, please contact your legislators and let them know that this is something that should be considered. That perhaps, and I can't guarantee anything, that if they're hearing from enough people that this is a frustration and concern, that they will take it up and maybe some changes can be made. But I want to let you know that I hear you, I understand, but there isn't anything that I can do to change that because the statute is written as it is. And we're doing our best at the Paid Leave Authority to implement it as best we can and provide help and support and guidance.
Thank you. Is the Connecticut Domestic Violence Program separate from the Connecticut Paid Leave Program?
It is separate, but what we say is that if someone who works with you needs to take time off because they're impacted by domestic violence or family violence, then they can take up to 12 days, which is what's covered under the family violence leave law in Connecticut. They can take 12 days of their time from their 12 weeks and be paid for that because we know it's very often women. You have to escape with your children in the middle of the night. You have to go to court. There's all kinds of things that need to be done when you are faced with family violence. And so the paid leave law does allow for compensation and income replacement while you're taking time off to attend to the needs that come about as a result of being impacted by family violence.
Is there any cost to employers for the paid leave program?
So there is no contribution that is required on the part of employers. It is completely employee funded. Employers' obligation is to withhold the 0.5% and remit it to the Paid Leave Authority. Other than that, and also they have to administer, if they haven't done this before, they have to grant the leave. Those are the only obligations that employers have right now.
Okay. What do we need to do if we want our payroll provider to pay these payments on our behalf?
Well, if you're using a larger payroll provider like ADP or Paychex or any of those large services, they already know. We've been working with them since April, and they're well aware of Connecticut paid leave, and they should already be withholding. If you're working with one of the smaller preparers, we've been working with their trade association as well. If your third-party administrator does not know anything about paid leave, let us know that immediately. Send them directly to our site. They need to contact us so we can make sure that they're prepared. But we've been working with them for close to a year now, so they should know.
Okay. All right. I believe that concludes our questions for the moment. Does anybody else have any other questions? I'll just give you a moment. I'm going to drop a link in the meantime in our chat for more webinar opportunities. You can visit our calendar of events at connecticutpaidleave.org. And I'm going to go ahead and put that into the chat for you all right now. If you're looking to find more information or content, we have several different topics that we'll be discussing over the course of the next few months. And we would love for you to join us. Andrea, we don't have any other further questions. Steve, I'm going to throw the ball to you.
Thank you so much, Amber, for your management of the questions, and thank you, Andrea, for your presentation. I have to say, the hallmarks of the public trust are clarity, transparency, predictability, all of the things that are critical for us to understand that our programs and that our resources are being managed correctly and to the benefit of our workers and employees. And your answers have really helped, at least in me, instill that trust in the working of your organization. You know, this is it's a complex issue. It's a complex administration and management. But these are important these are important dollars, people dollars, employee dollars, and the fact that you had such sound questions for answers for us for these really important questions is really critical. So I want to thank you for providing this webinar today. I want to thank you for continuing to do it. I know as we move forward, the questions will become more complex, more sophisticated, but every time rising to the call of the people of the state to really administer this program in the way that you are, I think is really beneficial. So thank you so much for your webinar today.
Well, thank you for your very kind words. And it's not just me, it's a very able staff of people who make this possible. And we share the philosophy that we are being entrusted with very precious resources. And so we believe that we must act responsibly and with transparency. So thank you. I'm glad that that's evident in the work that we're doing, and we appreciate that. So I want to say thank you to everyone who attended this evening, and we appreciate the chance. And if there's any other place where you think that we should be speaking to people, let us know. We'll be happy to do that. So I wish you all a good evening.
Thank you,
Thank
Andrea.
you. Good night,
Thank you.
everyone.
Good night, everyone.